Hello Year 11s and welcome to this video on the sources of law. The purpose of this video is to outline for you the two sources of law, that is Parliament and the courts, and then to look at the ways in which the courts make law. This information will provide a foundation for subsequent videos that examine in more detail lawmaking by the courts and lawmaking by Parliament. There are three things that you need to do as you watch this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you want to go over any information contained in this video. And the third thing that you need to do is have your summary books open in front of you. I'll give you some guidance as we go through this video as to what you should write in your summary books. Once you've finished watching this video, please make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then include that additional information in your Cornell notes. Let's get started then. On this slide, I've set out the learning intentions for this video. There are two learning intentions. Make sure that you write these down in your Cornell notes. The first learning intention is that you need to be able to describe the sources of law and classify a law according to its source. The second learning intention is that you need to be able to describe how the courts make law. Our first learning intention requires you to be able to describe the sources of law and classify a law according to its source. So let's start off by looking at this. As illustrated on this diagram, there are two sources of law. Make sure that you include this diagram in your summary books. The first source of law is Parliament. Parliament makes laws that are referred to as statute law. Parliament does this by passing statutes. Another word for a statute is an act of Parliament or legislation. In Australia, there are 9 parliaments. There is the Commonwealth Parliament, which is located in Canberra and which makes laws for the whole of Australia. In addition, Australia consists of 6 states and 2 territories, and each state and territory has 1 parliament. So, for example, there is a Victorian Parliament, which is located in Melbourne, the capital of Victoria, and which makes laws just for Victoria. The main role of Parliament, whether it's the Commonwealth Parliament, the Victorian Parliament, or any other parliament, is to make laws. The second source of law is the courts. Courts, that is judges, can make law when they decide cases. Now, you may have heard of the law of negligence. This law is that where one person carelessly causes injury or loss to another person, then the person causing the injury or loss may be required to pay money to the other person to compensate that person for their injury or loss. The law of negligence was gradually developed by the courts as they decided cases that were brought before them. In fact, it took about 100 years for the law of negligence to fully develop. The law of negligence was not made by parliaments passing statutes, but by the courts as they decided cases. The law made by courts is called the common law, case law, or judge-made law. Unlike Parliament, the court's main role is not to make laws. Instead, the main role of the courts is to resolve, that is, decide, disputes by applying existing laws to the facts of the case that they are hearing. However, sometimes the courts have to make law so that they can decide a case that they are hearing. Now, the courts, that is judges, make laws in 2 ways. These 2 ways are set out in this diagram. Make sure that you include this diagram in your summary books and that you make notes from the following discussion on this diagram, where these notes will help you to better understand the diagram. The first way in which judges make laws is by creating a new precedent or modifying an existing precedent. A precedent is a principle or rule of law that a judge makes when deciding a case. A judge will have to make a precedent where the case they are deciding is not covered by an existing precedent, with the result that the judge must decide what the law is that applies to the case. In these circumstances, we say that the judge makes law by creating a new precedent. A judge will have to modify, that is, change an existing precedent where the case they are dealing with is similar to a case that is covered by the existing precedent, but it is necessary to expand the existing precedent to cover this new situation. In these circumstances, we say that the judge makes law by modifying an existing precedent. When a judge creates a new precedent or modifies an existing precedent, the judge is making law because they are making a new principle or rule of law. All of the precedents, that is, principles or rules of law that are made by the courts, make up the common law, also known as case law or judge-made law. The second way in which judges make law is by interpreting a statute, that is, a law made by Parliament. A judge may need to apply a statute to decide a case that they are hearing, and this may mean that the judge must interpret or give meaning to words that are used in that statute. For example, because those words are ambiguous, that is, they have more than one possible meaning. When a judge interprets a statute by giving meaning to a word in that statute, the judge or court is making a law about the meaning of that word. So let me recap. There are three important points in relation to the role of courts in lawmaking. The first point is that while the primary role of Parliament is to make laws, the primary role of the courts is not to make laws, but is to resolve disputes. And it's only in the course of resolving, that is, deciding disputes, that courts may make law. The second point is that the courts can only make law when they are deciding a case. That is, a judge can't simply get out of bed one morning and decide that they want to make a law. Before a judge can make law, there must be a case brought by a party to the court, and that case must raise a legal issue that has to be decided by the judge. It's only then that the judge can make law by deciding that legal issue. In contrast, Parliament can pass a law about any matter at any time. It doesn't require a case to be brought before it. The third point is that judges make law in two ways. The first way is by creating a new precedent or modifying an existing precedent to cover the case that the judge is deciding. The second way is by interpreting a statute which applies to the case that the judge is deciding. When a judge is interpreting a statute, that is, a law that has been made by Parliament, the judge is giving meaning to words in that statute. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to do two things. The first thing is that you should be able to describe the sources of law, that is Parliament and the courts, and classify a law according to its source, that is, statute law is made by Parliament and common law is made by the courts. The second thing is that you should be able to describe how the courts make law. You must now read the pages from the textbook referred to on the first slide, and if you find any additional information from this reading that you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.